All right, I believe we're live. The clock has ticked and the light has turned red. So,
well, I enjoyed it, guys. That was a great discussion. I'm glad.
Yeah, it was a good
cleared
time.
up a lot of
Let's
things.
check out.
yes, I'm sorry. I see people in the chat are like, "You're late. You're late. You're late." No, 5 minutes is to let people get here. So we wanted to get here right on the 5-minute mark.
That's
So
right.
obviously, I am not Eric. I'm here with MLS, Southern Law, and Ian Corzine today, and we're going to talk. We're going to have other people jump in, but we're going to be talking about the craziness that's been happening this week. So why are we going to hide the ball? Let's just jump into the madness. The Epstein docs. So background: the Virginia Gouffre, a survivor of the Epstein issue. Now I have to be careful what I say because I don't want this to get demonetized. But she's a survivor of the Epstein scenarios. So Epstein, so with the Epstein issue, she sued both Prince Andrew, she sued Alan Dershowitz, and she sued a whole bunch of people. So during that lawsuit with Prince Andrew, he tried to get it dismissed, but it did not get dismissed. It went on. So Prince Andrew settled, and during that settlement, she dropped all those ancillary lawsuits for different reasons. But all that and then she also sued Ghislaine Maxwell. Now, in her lawsuit against Ghislaine Maxwell, that I believe that settled too. But all the information about depositions, what happened, who was involved, they had gotten all that testimony, and I think this lawsuit started in 2015. So they got all that. And the judge, remember, like after Johnny Depp, remember after the case, the judge was like, well, there's no reason to keep this all secret anymore, so I'm going to release it because the case is over. Same thing with the Ghislaine Gouffre versus Maxwell lawsuit. It was like, well, the case is over. Why am I still holding this thing under seal? So the judge has unsealed it. Now, there are a couple of names that were left off because they're still fighting to keep their names under wraps, but they've unsealed all of the documents and the names have come out. Names. Now, one thing I think the news media has been crazy on is that they make it seem like this is just a list. And if your name on that list, you are associated with Epstein in some way. But some of the people's name on the list weren't like. In other words, Epstein said, I know Leonardo DiCaprio. So his name is in there. But now, so people are like, oh, he's on the list. But he's not on the list. He just said his name in passing. Trump, for instance, is another one whose name was mentioned, but he didn't have any dealings with it. Like, hey, we're in Atlantic City. Let's go to one of Trump's properties. Oh, so his name, even though being mentioned, it's only mentioned in this
specifically with regard to Trump, though, the testimony is that Trump said no over and over and over, and eventually kicked Epstein out of his Mar-a-Lago estate or whatever. Yeah. So that's a little bit more. It's not like, oh, we just mentioned in the passing.
And Nate, also, I wanted to bring up that it's really not a list. That's the thing. It's so funny. The term Epstein list was trending. And if you made any videos about it, you put Epstein list, but that's not the truth. It's 900 pages of documents, which, like you said, include various names. And it could have been names that just someone, I love Harrison Ford. His name will appear in those documents. So it's a little disingenuous the way that MSN has portrayed this information.
And the way all the headlines are is Clinton and Trump named in Epstein's list. Like that's the leading headline right there, right?
Yes.
It's like, well, okay.
But now, so let's talk about. Well, we just spoke about Trump being named in the document, and if you note, I watch a lot of left wing media, from Media Touch to MSNBC. So they're trying to, the way they frame Trump being on the list. It's in a weird way when they'll say, okay, Trump was named, and even though these are inconsequential, they'll say, but look at this video from 20 years ago when he was at a party with Epstein, to try to make the connection a little more sound. But then on right-wing media, they do the exact opposite with Clinton. But with Clinton, I will say, if anyone is implicated in the Epstein thing, I think, because didn't Epstein have a picture of Clinton in a dress and all this other stuff? And
he had a painting, yes.
Yeah, and Clinton was mentioned in the documents over 100 times. So I think the relationship between Clinton and Epstein is a little bit more flushed out than the relationship between Trump and
Well, Nate, I think it's beyond that. I did a video yesterday on just the Clinton connection to the Jeffrey Epstein list. Documents. And really, it's more than fleshed out. I mean, obviously, we have a lot of hearsay evidence that's in these documents. It's like Joanne Soberg heard Jeffrey Epstein say that Bill Clinton likes him young, referring to girls. But we also heard some very interesting stuff, some stories I hadn't heard, but even though I guess a lot of people who were paying attention had heard before, that Bill Clinton traveled with Jeffrey Epstein on the Lolita Express. I guess it's disputed, but 6 times. 4 or 2 of those times was to Africa. And on those trips, there was no Secret Service logged onto the flight logs, which is very, very unusual for a president, especially a president, as recent as Bill Clinton was, to be traveling without Secret Service, and also especially to a continent where it's arguable that there's some probably danger there. So we really have I have more stories than that, but there are some crazy stories about Bill Clinton that are in those documents.
And let's not forget about the Bill Clinton getting a massage from one of the Epstein victims. Like that picture is out there. Right?
Yeah, that picture.
I don't know if people saw it. Yeah, I don't know if people saw it. I'll pull it up, but
pull
that's
it up.
pretty damning.
Yep, that's in my thumbnail.
Let's just say you don't have pictures of Trump in that position.
No. But the problem is though there were so many Epstein issues because, like I said, the one thing Bill Clinton, I think the saving grace of this whole thing is that he wasn't actually named as someone who was doing something wrong with these women, right? It was like he likes them young. Nothing was like he did this. I had blank with Bill Clinton. So,
but you know what? You got to remember, guys, there's a fact that people kind of discount, and that was, especially with respect to Virginia Giuffre, there was a settlement with Jeffrey Epstein. And I don't remember if you saw in the settlement that it was not just against the main defendant, Jeffrey Epstein, but it was with other related parties and other defendants. And one of the reasons why they say that her testimony and other people's testimony in the documents is different than as she alleged early on to magazines and various newspapers and things like that is because she was barred from saying bad things about Bill Clinton and these other defendants in the settlement agreement.
Okay, to be fair though, does that woman, girl, whatever, does she look underage? Because I don't think she does.
Well, she's an alleged. Well, she was alleging that things happened.
17 years old, at the time.
Yeah. So she wasn't. So, but now let's go to some of the other people who were more prominently named. So let me set this thing up for you. So there's one of the accusers, one of the people who were accused from the Epstein Island. So the person, at first, I was just there because I had business relationships. But then it came out that there was a calendar. And on that calendar, it had this person's name getting a massage at Epstein's house.
Yeah.
So the person then had to admit, well, yeah, I got a massage. But the person says they got a massage from a 40-year-old woman named Olga in Epstein's house. So their massage wasn't from one of these sex slaves that he had running around. It was from a 40-year-old. And he also paid with the check.
I want to see that check.
That's his defense. So
I want to see that check.
So let's watch this person explain after this happened. Let's watch him explain exactly what happened and why him getting a massage in Epstein's house around this time was totally insane. And just to be clear, he's been named in the documents by I think a couple of victims that they were forced to have relations with this person. So let's listen. So again, listen to his retort of the whole thing.
And I want to pick up on your point about the travel records. And you've said in the past that she can't connect to you in any way, any sense that you might have met before. I haven't heard you respond directly to this, and I wanted to give you a chance. There's in the travel records, it says on December 11th, 2000, the Epstein plane leaves Florida for New York City. You're living in New York at the time. Then on the next day, December 12th, the calendar says a 1:30 meeting with, quote, Jeff. We don't know what Jeff that is. People could speculate. And then at 12:13 on December 13th, the next day, it says 10 a.m. scheduled a massage with AD, presumably Alan Dershowitz. 14th, the plane leaves.
That was in my wife's calendar. My wife scheduled a massage. If you think my wife scheduled a massage with an underage sex slave, and then
she doesn't know any better.
No, we lived in New York. I was
other
a
calendar
finish.
entries.
Let me finish.
Can you guys clarify that?
Let me
finish. Had a collective.
Let me finish. I was a visiting scholar at NYU. My wife had professional masseuse. We have checks, canceled checks, proving that the massage occurred, when it occurred, who it occurred with. And I've had very, very few massages in my life. One at Jeffrey Epstein's house by a middle-aged woman who gave me a shoulder and neck massage, which I hated. I called up my wife and complained about it immediately. No,
complained.
If you want to put me on trial here, you have to give me an opportunity to fully explain. You will not be able to make just charges against me without giving me an opportunity.
You had a massage at Jeffrey Epstein's house? Do you know who it was who performed that?
Yes. I mean, we know approximately who it was. There were a lot of people around her. We think we remember, and the person who was in charge of the Epstein house confirmed this, that it's a woman named Olga who was in her 40s and was a professional massage therapist. I had a neck and back problem at the time.
Is that convincing?
No.
Well, it's Alan Dershowitz. What do you expect? I mean, of course, he's going to go the plausible deniability route. Of course, he's going to, say, yes, it was my wife who was involved in that. I mean, it's what he's giving the best defense he can possibly give, and he's Alan Dershowitz. So of course he's going to, now whether that's accurate, I can't say, but that's his story and he's sticking to it.
Now, Chandler, I was going to say, do you think this is a good angle for the future interviews? You think that's a good way to present your defense? It's unbelievable, that guy.
Yeah, I don't know. All of a sudden, you know the name, but you really didn't know the name. It may be Olga, but it's not Olga, but her name is Olga. She's 40 years old, and my wife. It's like there's a lot to that. Now, mind you, he may be innocent from all these things, but I don't know what to say. That's not convincing to me. That's not convincing to me. Maybe did he convince anybody here that it was all innocent? The massage.
No, I want to see those checks. He just said checks. There's records of those. I know Chase Bank goes back like 30 years with checks. Show me those checks.
I'm surprised it wasn't cash because I know that Epstein used cash frequently. That was he almost exclusively, and it was how long ago was this?
How do you know 90s? That? That's true.
Well, I've done my research. I actually am doing I'm doing an episode today on female predators, and I'm going to be talking about Ghislaine Maxwell. And I know that you covered that trial, Joe. But I was watching some documentaries last night to kind of go over the history. I didn't really know a lot about the Epstein stuff.
The Ghislaine Maxwell trial. So the only of the four women who testified, the only one who testified under her real name, using just her first name, was Marianne. Marianne testified that when she was 12, somewhere between the ages of 12 and 14, that she basically would make regular visits to him once or twice a week, and that Ghislaine Maxwell helped set that up. The reason I'm saying you're correct is that, and I bring up her testimony specifically, is because her testimony was bolstered by and corroborated by her boyfriend at the time, who said that Virginia Guffey is the one who introduced her to, and the three of them and a fourth person, a guy, were like all friends, and that she's the one who said you can make quick cash this way, and he explained that they would cross over from Palm Beach into West Palm Beach. They lived in the poorer area of Palm Beach, right. and that they would cross over into West Palm Beach, and that he basically had a whole bunch of girlfriends, and she was pretty much kind of like, he was like a pimp practically. Mm-hmm. She would perform her massages and then come out with the money, and he would wait outside. And he mentioned that he would always he'd always buy something in West Palm Beach, and they were like, why would you buy something in West Palm Beach? He said because Epstein would give her $400 bills. And he's like, you can't break $100 bill in Palm Beach. You have to do that in West Palm Beach. No one's taking $100 bill from you in Palm Beach. So it was so detailed and such interesting, little minutia like that it it's stuck in my memory. 2 years later now. So that's why when you mentioned that he used to use cash a lot, I was like, wait a second, Chandler, how do you
Yeah, because all the testimonies of all the girls, you know, they all said, you know, and there's cash for you on the table, there's $200 for you. It would be, and then whoever referred, there was that one girl, Michelle, who she didn't want to participate.
Every girl you would bring, you get another 400 on top for that.
It was her ticket out of Palm Beach. It was her, you know, that was her opportunity, and she referred like 26 girls, something like that. She was a pimp. She was 16 years old. I mean, she did the referral system.
I think it's referred to as the bottom B, if I'm not mistaken, in the hierarchy.
Well, bottoms are
terminology also. My God, you guys are such experts.
Actually, a bottom is one of the more higher ranking female individuals in a sex trafficking position, and I'm actually not sure if
second in command.
Not necessarily, but I'm not.
I don't know.
I'd have to pull up my research on that.
Well, sorry, I might have it backwards. Mr. Patrick is saying I have it backwards. It was West Palm to Palm Beach. I might have that backwards, but yeah. That makes sense because the rich people were on the water, and I was on the East Coast.
It's a 45-minute drive. Yeah.
Yeah. So the west side they cross over a bridge. So that would make sense. Actually, that was Palm Beach is the rich people, and West Palm was the
So before we move on from the Epstein stuff, is there anything that surprised you guys about the doc drop? Because it was the buildup was crazy. But the docs eventually dropped. Was there any surprises? Did anybody feel like, oh, I didn't know this versus I didn't know this?
Well, there were some women who were mentioned. I think Naomi Campbell was mentioned. Yeah. I'm trying to remember who else.
Well, if they're mentioned, though, they weren't necessarily involved.
Sure, but they were witnesses, and they were women who I hadn't previously heard of as being witnesses in the Epstein debacle.
I think the most important thing is this just basically confirmed everything that was being said out there. And that other people were saying, well, that's just rumor, and there's nothing to support that, and it's just BS, and now it's been confirmed. I think that's the most important thing.
But the thing is that you know, especially those who were just using his plane without actually going to, you know, Epstein Island or his other place. It's like that's what rich people do. Is they sort of like, it's not surprising that they use each other for favors. If you know, it's so, and you can and theoretically you can say the same thing for both Trump and Clinton. Like I think it's disingenuous to say that this is the smoking gun against the guy I dislike. Like I think that's a very disingenuous take because I think at the end of the day, you know, it really seems like rich people just using rich people. Now, some people on the Trump camp will try and point harder at Clinton, saying that Trump was using it really to fly back and forth from Palm Beach to New York, whereas Clinton was globetrotting into parts of the world where underage girls are more easily attainable, and there's rumors of statements that were made by Jeffrey Epstein that Clinton likes him young. That's one of the girls testified about that, you know. So that's why the Trump camp, I think, is salivating a little bit more over this than those who are on the Democrat side. But realistically, even if, you know, that could just be a statement he made, that's not really a smoking gun against him. And even going to Southeast Asia, I mean, he uses a cover that was for the Clinton Foundation work. Is it possible it's completely a cover and that he really was a slimy dude doing everything that a lot of people on the right believe Clinton was doing? Definitely. Is it possible that it's legitimate? I guess it is kind of possible it's legitimate, and that's why I think that this is a lot of hullabaloo.
Well, along those lines, I was going to say, Joe, I believe that there is kind of a smoking gun with respect to Bill Clinton, but we can reserve that for another day. But Tim Anton,
what's the smoking gun? Tell me, I'm curious. I want to.
Well, I think he likes him very young is a very important part. There's also a discussion in the documents where they talk, and it's disputed, about a dinner they had with Bill Clinton on Epstein Island and other girls.
Really? There are flight logs that show him going to Epstein Island? Because I don't remember seeing anything of that kind.
No, there's just testimony to that effect by Virginia Guffrey, who later recanted that testimony. But again, I don't know if you listened, but there's also a settlement agreement that she had with Jeffrey Epstein to settle their civil lawsuit. Yeah. It may have prevented her from testifying that way. But one of the things I wanted to get to real quick is this Tim Anton guy says Epstein is a distraction. Do you guys believe that these document release right now is a distraction? And if so, what is it distracting us from?
Hunter Biden.
Hunter Biden?
That's what I think. I mean,
tell me more about it.
No, I mean, I don't know. I'm just trying to think of, like, he's being charged now. His charges were increased, and then all of a sudden we have this being released. But it's just I don't think it's coordinated. I just think they're taking an opportunity to not talk about anything that's really against Biden. Like, who cares about Clinton? He was 20 years ago. He was president.
Well, that's exactly right. And these documents are old. Many people will say most of the information was already known if you really wanted to research it or ask questions.
Yeah.
Why now? I mean, I was sitting at dinner with my 11-year-old daughter, and I mentioned that I made a video about Epstein. She heard that key word, and she goes, yeah, what's this thing I've been seeing on TikTok for the last 3 days? Is Epstein list or whatever? It's clear that there is a campaign out there to be able to flood mainstream media, TikTok, Instagram, all the different social media platforms with the Epstein list. And it's information that basically was already known. So to me, it doesn't make sense at this time to really think these are new developments. It sounds to me like they're pushing us into a direction to analyze 900 pages of documents so that we don't look into something else. But that's just my perspective.
Well, they also might be trying to force us into analyzing it for a Trump connection, because Trump is still relevant, unlike
True.
Clinton. And, again, the headlines are, Trump and Clinton are listed in Epstein. And if you look into it, it's like, okay, well, Trump turned him down and eventually excommunicated him from Mar-a-Lago. But who knows? Maybe there's more out there. Maybe they were really excited and pushing the issue because of Trump, because he is relevant. And
it's all about Jimmy Kimmel.
Jimmy Kimmel.
That was interesting. I think that was
what was the Jimmy Kimmel thing? I missed the Jimmy Kimmel connection.
His name did come up.
Yeah, so somebody, what's his name? Aaron Rodgers went on the show, and I thought he was joking when I first saw it. I was like, oh, he's joking, obviously. He said Jimmy Kimmel's name. He wouldn't be surprised if Jimmy Kimmel's name was on.
No. He said that's not what he said. What he said was less defamatory, because what he actually said was, when they were talking about the Epstein leaks coming out, he's like, well, I can think of some people who wouldn't want that to happen, like Jimmy Kimmel. Now, that doesn't mean that Jimmy Kimmel's on the list. It just means that perhaps he has friends who are on the list who he wouldn't want it to come out. But it could certainly be taken as speculation that his name would be on the list. And when Jimmy Kimmel started screaming on Twitter, you better watch your mouth, or this is going to end up in a lawsuit. I was like, dude, nothing he said there is possibly, would you possibly yell? To win a lawsuit.
Spouting off, that was the first name that popped to mind.
Yeah, but they apologized for it. I know what's his name, McAfee. He apologized for it, but I think that was the overlords at ABC.
What happened to the Man Show, Jimmy Kimmel? I miss him.
I love the Man Show. That was my favorite. Girls jumping on trampolines. That was like, I remember being like 8 years old.
The Man Show now is you cannot do anymore. Not in this.
No way.
It's
never.
So sad.
He's gone so far the other direction.
Well,
yeah, so woke.
You know what? So now, because I think we've hammered the list together, the evil list, but hopefully, but again, this drip of the list, and there's more documents that came out. 300 pages came out last night. There's going to be like another couple of thousand pages of documents that still have to come out. And this drip. We'll see if there's anything new. But right now, it essentially confirms everything we knew. There are a couple of people who've been implicated by some of the accusers that said they had sex with these people. But again, you got to take it for what you will. Also, just so everybody understands, there's also the narrative going out there that I definitely have to make sure. They're saying that Ghislaine Maxwell, her attorneys and her people are saying, how crazy is it that she, as a woman, got sentenced and prosecuted, but all these men who these young women are alleging did this to them are still free, like Dershowitz and like the governor of New Mexico before he died, and so other people. So that is
what Chandler's thoughts are on that one.
That's what she's out there saying. Look, she's the only woman. Go ahead.
They're really playing the feminist card with this one, and it's something that her attorneys did ever since their opening statements. In the opening statements, they used biblical references. They talked about how ever since it was Adam and Eve and the apple, women have been blamed for things that bad men have done, and she's nothing like Epstein, and she's never been anything like Jeffrey Epstein, and she's not Jeffrey. And they're coming out with this statement, like this has always been a story about men abusing women. And that is not what the story is about. This is actually a story from, if you're talking Ghislaine Maxwell, It's a story of a woman who not only facilitated abuse, but participated in it. She groomed those girls. She was 100% in charge of overseeing all of the, the different elements of bringing them into the fold. She personally sexually abused those girls. And she would abuse them without Jeffrey Epstein around. So she was a predator. And they referred to her as a rare female predator. But the fact of the matter is that there are a lot of female predators out there, and they go undetected because they're female. And I'm going to be going into that today on my show. But I am really disgusted by the way that her lawyers have framed this, because she is guilty. She is responsible. A jury found her responsible, and she deserves to be in prison. And I don't care, what people say about this. A lot of her victims said that she was worse than he was because she knew.
She's a terribly evil, vile human being, and I'll tell you right now, her counsel was very effective, very, very smart counsel. But I actually spoke to them a couple of times during the course of the trial, and I tried pushing them toward getting these flight logs out public and like making a bigger stink about them. I actually spoke to, what was her name, Bobby, the woman who represented, and she's the one who gave closing arguments and used the analogy that you just said, where she was talking about how ever since Eve, men have been blaming their wrongs on women. Yeah, and she and they definitely, and that's why right now, and I actually went over to her. I said, don't you think that it would help? It could potentially help your client. I knew that she was going to go away. I mean, the evidence was just so powerfully crushing against her. But I was like, I really want these flight logs coming out. I want everyone to see them. So I was like, don't you think that could actually help your clients if you actually made a bigger stink about making these flight logs public, because only some of the logs were coming out, not all of them, and that you should be making an argument. And it was because it was very frustrating that as hard as the government was going after Ghislaine Maxwell, they seemed to be equally dedicated toward protecting the people on this list. It's so much so that Judge Nathan yelled at the government when they submitted the redacted list, that they were like, that she said, why did you redact so much? They were like, well, we were looking to protect these girls from being exposed. That's why we redacted. She's like, you redacted 97% of the names. That doesn't make any sense. And she like started yelling at them that she wants them to start like unredacting. So they unredacted some of it, but there still were some names that were redacted. So and I really wanted an unredacted list to come out, which is why I tried pushing her counsel and to say, one side you would think either the government or the defense would feel like having an unredacted list. For one of them, it has to be advantageous. If the government didn't feel it was advantageous for them, well, then certainly you would think the defense would think it's advantageous.
But she saw what happened to Epstein in jail, so she probably wasn't trying to push for names to be released.
Oh, you think that she was afraid of having the
unalivement?
Yes.
Yeah.
She had to be afraid.
Was the flight logs released as part of this batch? I haven't looked at them personally myself.
These were depositions, and these were deposition
transcripts primarily is what it looked like.
So I haven't seen fight, but I don't know. Maybe somebody correct me if I.
And so that's the other thing too. Like when we talk about the phrase Clinton liked him young, right? So that's it's hearsay within hearsay. At least two levels of hearsay. It's not necessarily admissible in court, but presumably there is information that can help actually support that too. And when you're asking questions in deposition, it doesn't necessarily mean that you can ask the same question in court, but you use it as an investigative tool. So there might be more information out there that's available. Don't chalk it off because it's just hearsay within hearsay, but also don't be like, this is the be all end all either with any of this stuff. Because
I just think if he was named, like, again, like the people who were named, like, the victim said, I had sex with this guy in this place at this time because this guy told me to do it. Those, I think, are a little bit more compelling.
Yeah, that would be much more compelling.
Yeah.
They have, but some of the people named in the document, that's what happened. The victim said, I had sex with this person at this time at this place. Alan Dershowitz has, there was 3 different locations. Now, just to be fair to Alan Dershowitz, one of the victims, Virginia Giuffre, did retract her story and said she may have been mistaken with saying, but then he was named 3 other times too. So, and there's a whole bunch of people were named 3 other times.
Virginia's credibility from my end is really shaky.
Yeah.
I mean, somehow she was a victim, and then she got money, and then she becomes a victim again. It's like she just. How does someone end up becoming a victim on two different situations in her life? It's very.
And she was recruiting too. She was a recruiter,
and
too.
she's a recruiter. I'm like, I have a very hard time. I'm not. Look, I feel bad for her in the sense that she certainly had a miserable childhood, but. There's so many recantings and so many back and forths in her the arc of her story that it's just like I have a very difficult time taking things that she says that lack corroborating evidence as really being something that we should be relying on. But there are other women. There are other women who naming Dershowitz.
Jane Doe number 3 said that she had relations with Dershowitz 3 other times. One time in Florida, New York, and in New Mexico, but she also said that she was forced to have sex with other men. But yeah, she named Dershowitz straight out.
Jane Doe number 3 being Marianne. Is that because she was the third one to testify? When you say Jane Doe number 3, you mean from the Maxwell trial?
From the it may be from the Maxwell, but from the transcripts, she's listed as Jane Doe number 3.
Because in the Maxwell trial, they named Jane Doe number 1, Jane Doe number 2, Jane Doe number 3. They called her Marianne, and the fourth one was Annie Farmer. Was the only one whose full name that they used.
But these are from the Maxwell trial. Well, these are from the Maxwell civil trial.
Oh,
I'm not sure if the Jane Doe's align that way.
Right. That they probably don't. They probably don't. Right.
No, from several of the federal, it wouldn't make sense. Although Dershowitz would have you believe that it wasn't, Jane Doe number 3. It was just a 40-year-old woman named Olga who he had slept with. So,
did he just implicate his wife because he's like, my wife scheduled these for me? This is why you don't talk, people, because you might have just implicated your wife in a criminal endeavor.
Well, and then that eviscerates the privilege, right? She's now a co-conspirator thing, so now we don't have any marital privilege now. All right, so now moving on. Now, even though I feel bad because that's just like the crimes of blank activity, I got to be careful because YouTube is so crazy. All right, so most of you guys are probably familiar with the term statutory blank. Like I can't say the regular word because I don't want to be demonetized. Well, statutory blank generally deals with adults having relations with minors, but did you guys know that there are some states that have statutory blank when it comes to adults?
In prisons?
Not only in prisons, in regular life.
Like the only thing I could think of is like an adult, so like a college professor or something. I don't even know if that would count.
So what happens is some states recognize the power dynamics in certain professions. So, for instance, boss versus employee, teacher versus student, professor versus thing. So no matter how old the person is, if you're more than 4 years older than them and you're in one of these special relationships, the state
assumes you cannot consent.
You cannot consent, and it's statutory.
More than 40?
That's weird.
More than 40 years older? That's a significant age difference.
I'm actually gonna play it for you right now.
I think Andrea Burkhart was talking about this.
I think it's four. He said, not 40.
Yeah, 4 years. 4 years. More than 4 years. They're senior.
Oh, so that's very different. Yeah.
Here's an example.
Okay.
Here it is.
Okay.
Carolina, it is illegal for a teacher or any school personnel to have a sexual relationship with any student if that teacher is 4 years older than the victim, which in this case she was. It makes no difference whether the sexual activity was consensual or not. And according to the law, in cases like this, teachers, administrators, or coaches can be charged with a felony.
Is this elementary?
The student is in a position of vulnerability.
No, is this
college, university?
This is any school scenario in the state in which the person, the coach, teacher, whatever, is 4 years older than a student. So if you're older than a student by more than 4 years, you can get charged with a felony. So in this particular case that you're seeing on the screen, the teacher was arrested. The teacher was 26 and the student was 18. They had relationships, so they charged her with 5 different felonies because she had sex with the student 5 different times. Now, there's 2 exceptions. One, the age difference. So if she was 20 and he was 18, that'd be okay. And the second thing is if they were married. So if they got married and had sex, it'd be okay. But in this, they consider the power dynamic between teacher, student, coach, student, whatever, so intrusive to consent that they've essentially legislated statutory blank for adults.
Nate, I'm going to ask you to rewind a second. I think you said if the teacher was, let's say she was 21 and he was 18, that would be okay?
Yes.
Yeah, because within 4 years.
It's within 4 years.
That seems okay. That doesn't make a lot of sense.
I remember a student teacher. I was my senior year. I was in high school, and there was a 21-year-old student teacher, and she was cute.
She committing some felonies over there. I'll play it again. I'll play it again. Here it is.
Attorney. Okay, so in North Carolina, it is illegal for a teacher or any school personnel to have a sexual relationship with any student if that teacher is 4 years older than the victim, which in this.
So even if the student is 21 and the teacher's 26, that's a felony.
Yep. Now, I imagine this charge is in a high school, correct? This is not college.
This is the high school, yeah. This is the high school.
Now, would this apply to a college setting? Because I can get behind the idea that kids, even though they're 18 and they're technically adults, they're still in high school. We don't want that, right? I can get behind that idea. But what about college age students? Now, let's say the student is 18 and he's in his first year of college, and his professor, or probably just a adjunct lecturer, is 26, right? Does that apply? And because that's where I start running up against. We're legislating
in college. It could be a 40 and 45-year-old.
Well, I guess, yeah, community college, right? I'm trying to use the same ages of the parties, right, and throw them in a university as opposed to the high school setting. Is that still a violation of law? Because now I start having issues with that. Because
well, I'm assuming that this is really for schools up to high school level, but it may be for college. But I don't think this is North Carolina.
Yeah, so let me mention on that if you're less than 4 years older, it's still a felony. It's just less of a felony.
Really?
So it's not okay. The statute is 1427.32, and it says if the person is less than 4 years older than the victim, it's a Class I felony. Otherwise, it is a Class G felony.
What's the statute?
It's NCGS 14-27.32.
What's the penalty for a Class G felony?
Yeah, I'd have to look it up. But one thing to remember.
0.32?
Let's see. It's 14-27.32.
Okay. Oh, I see here. All right.
And in North
Class
Carolina,
G sounds really low. But
in North Carolina, there's no statute of limitations for felonies.
Ooh.
Wow.
Well, one thing that's interesting with this case, though, is that it does rub up against the whole. Well, I don't know if you guys remember Lawrence v. Texas.
Mother phrasing.
That's true.
Sorry.
Rub up against the Lawrence v. Texas. But in Lawrence v. Texas, one of the more interesting things was that the justices said, well, you couldn't, because the law in Texas was you couldn't consent to same-sex relations in the state of Texas. So any of those acts would be illegal. But the court said that that two adults can consent, and then said, the only way you can make laws against people having that type of relationship, even heterosexual ones, was in situations like prison guard, prisons, so forth and so forth.
Okay.
But now, does that now equate to, let's say, a prison guard prisoner relationship, or is it something that which would be okay? Go ahead.
Listen to the way this is worded, though. If a defendant who is a teacher, school administrator, student teacher, school safety, blah blah blah, coach at any age, or who is at the school or school personnel, and who is at least 4 years older than the victim engaged in that sort of stuff, at any time during or after the time the defendant and the victim were present together in the same school, but before the victim ceases to be a student. Okay, so they don't have to be the direct teacher. They just have to be a student at the school, and you have to be a teacher at the school. So again, going to the college scenario, female teachers or male teachers don't hang out at the bars where the students are unless you're going to check them for their school ID, right?
But I think if you go down to the bottom of it, the definition of school, it sends you to 14-202-4D, and then that sends you to Chapter 115, and I think it's just... I
think it goes up just to high school.
Yeah, I think that's correct. Elementary and secondary education, so I think they define it out of it.
They stopped it, they stopped it at high school.
Because it doesn't define it here,
But even at high school, well, first, The
Well,
fact
still then,
that I think this teacher should definitely lose her job. No doubt about it, right? You're having sex with students. You're going too far. But now, what about the constitutional aspect to it? Can someone who's 18, should this be is this an infringement on their constitutional liberty to have sex? Because don't forget, you're infringing on the students who's an adult liberty to have sex with whoever they want, and then you're infringing on the person who, the 26-year-old.
If we're going to go with stare decisis, then I would say yes, it's completely constitutional, although I don't agree with it fundamentally, because technically prostitution seems to be, name one other activity that you could do for free all day long, but as soon as you pay for it, it's illegal. So I feel like that in and of itself might be an infringement, but since that's not, I think stare decisis would have to say that it's perfectly fine to legislate this. If I was to go with that analysis, I mean, we legislate. I remember in law school there was this one student. We were talking. It was like a real property class, and she was like, "How can the government tell me what I can and cannot do on my property?" I'm like, "Well, you tell you they can't. You can't smoke crack in your home. It's completely fine. There's inroads that the government can make into your daily lives, and this is one of them, apparently, according to the 200 years or so of history we have. So I think, given that analysis, they would be able to.
I'm looking at this about the harm. I'd love to read the legislative history and figure out what was the purpose, why did this come about, what politician introduced the legislation that got passed. Because I'm not arguing that teachers should have relations with students, but at the same time, there is a real big point about freedom of expression and freedom of association when it comes to an 18-year-old. I mean, we really have to remember, I know that there's some sort of special relationship between teachers and their students, but when we're talking about, a 24 and an 18, to me, it seems like it is unconstitutional.
Now that you say that, I'm sorry, I wanted to point out one other thing. It says at the same school. So this doesn't even have to be a direct teacher. It just has to be a teacher at the school and a student at the school. So given that wide-reaching sort of range that the statute has, there might be an issue with that, as opposed to the direct subordinate superior relationship that you would typically expect.
Well, is this going to prevent relations like this from occurring, or is it just going to give disgruntled, unhappy, probably female students ammunition to go after the fact, after consenting, to have a weapon, some kind of ammunition against a teacher that they had the hots for, and that maybe things didn't work out so well? I mean, I don't think it's going to prevent relations from occurring between students and teachers. I think it's just going to give some individuals more weaponry, to get their way, and perhaps get some kind of punitive actions going. And it makes it easier for female false accusers, because they don't even have to necessarily lie. They don't even have to say that it was non-consensual. They can just say, oh well, I'm unhappy about this now, and so now I'm going to go to the government, I'm going to go to the law, and to tell this story. And even though I engaged in it willingly, now it's illegal. I mean, I see a big problem with that.
Is there, because it's First Amendment, this would be a strict scrutiny analysis?
I would imagine it would be, but I haven't looked at any of the analysis regarding the other women of negotiable affections. So, to steal a quote from Legal Vices, I haven't looked into those the case law that's interpreted that and analyzed that.
Well, Lawrence v. Texas, it was a rational basis with bite. So the court essentially said there was no rational basis to the law that restricts two consenting adults, not in prostitution or whatever, from just having consensual sex, even just because they were same sex. So if you just take that logic, you would go to
the reason why I go to the women of negotiable affections is because presumably it's consensual, right? And so we're talking about a consensual relationship. Understanding that the courts treat juveniles much differently, I wouldn't necessarily go to the juvenile consenting relationship because we have two adults here. So I would go more towards
with juveniles. You have classic statutory. You wouldn't need the statutes.
Yeah. Right. But that's
this is statutory.
I'm just trying to figure out adults. What basis the court would judge this on constitutionally. Would it be strict scrutiny? Would it be some sort of hybrid or something else?
Because it's difficult. You're already pointing out examples as to how this would likely fail strict scrutiny. Because why would it have to be any teacher in the school? It could just be someone who's actually a teacher of that student. That would be a more narrowly tailored statutes.
What about
to effectuate protecting someone who's in a weaker position in a power relationship?
What about your mom's friend that's really hot and just volunteers every once in a while at the school? There's a lot of scenarios that I can conjure in my mind as to where we might run into some problems.
Well, again, we will see how this is going to be constitutionally challenged. But now, one of the other issues that have come up when we talk about these particular issues, because it seems like this is just one of those days, is the way men versus women accusers, about those who are accused, are treated.
Yeah.
So, for instance, here is a story of some. Now, just to set this up. A woman is accused of doing this to young men in school, but not only are the parents on the person who's accused side, because this person happens to be an NFL cheerleader. So the parents are cool with it. It seems like even the administrators are cool with it, but obviously the law is not cool with it, and she was prosecuted. So here is the story of Sarah Jones, former NFL cheerleader for the Bengals, and she was she was a naughty teacher.
Cincinnati Bengals
she was a hero.
Teacher charged with having a sexual relationship with an underage student. The trial was set to start this week, but today Sarah Jones is due in a Kentucky court to accept a reported plea deal. ABC's Paula Ferris joins us now with the very latest on this. Paula, good morning.
Good morning to you, Amy. It's a complete 180 for this former Cincinnati Bengals cheerleader. Just a few months ago, Sarah Jones pleaded not guilty to having sex with a minor, but her attorneys tell ABC News that today she will accept a plea deal.
ABC News has learned that Sarah Jones, the former pro football cheerleader and high school teacher accused of having sex with a student, will avoid a very public trial set to start later this week. Jones's attorney says later this morning she will accept a plea deal after originally pleading not guilty in April to first-degree sexual abuse of a teenager.
People don't know the...
Now, just for the time's sake, she was facing years in prison with the first-degree charge, but they essentially gave her an extremely light sentence. Now, this is because the parents came forward, some of the victims came forward, and even some of the people in the community came forward and said that this was ridiculous, that she was even being punished. That she was even being punished for this because everybody essentially loved it. But and obviously so the state. So it's the thing that's fascinating is about the gender dynamics between a hot female cheerleader being charged with this and her getting a sweetheart deal for if she was a man. Do you think that they would be giving her a sweetheart deal?
Well, and I think that's the problem is that gender roles really play a big part in this, because if that was a man and the victims were women, everyone would be screaming, castrate this guy, throw him away forever. So gender roles really do play a role in this, which I don't think they should, but I don't know if they should or shouldn't, but they definitely do. Bifrons is in chat saying can't be alone with students. You need cameras and audios everywhere. The problem with that is like I golfed with my teachers when I was in high school, and like one of my teachers was a piano instructor and helped me a little bit and stuff like that at her home. And you kind of ruin that relationship if you have to like everything's got to be in the classroom where cameras can see you.
Well, it's just fascinating to see how, even though how far we believe we've come, I still think a lot of these gender norms still boil up in situations like this.
Should we treat it differently? I mean, I know we can't, right? The Equal Protection Clause and all that stuff, we can't. But should we treat it differently?
I think, personally, I think not. I think, unfortunately, if we're going to protect children from this particular thing, then it shouldn't matter the gender you are. Even though I understand in reality it does, but I think legally it should.
It should only matter how good looking the perp is. That's the only thing that should matter.
Well, like there's another YouTube channel that I listen to, a local one, and they award teacher of the year awards based on this very thing. They have like a thing at the end of the year where they talk about these stories and like, here's the teacher of the year award. But they're all hot women, and and they don't see anything wrong necessarily with the guys getting to be with their older hot teacher.
But Nate, I got to clarify just for one moment. I mean, are you basically saying should, female teachers who are accused of this crime we've talked about, should they get lighter sentences than male teachers? And, that goes into a lot of things. You talked about gender roles, but this appears to be a plea deal. So it was agreed to. It was also public pressure, and the prosecutor obviously suggested it or negotiated it. Having done that myself, there's a lot of other issues besides, man, women always get it lighter than men. No, it just happens in that community. That's what happened. But in other communities, I don't have an example, right now, but I'm sure there's other situations where the woman got a higher sentence than the male. So I don't know that this necessarily implicates gender roles. I really believe in our system of justice, and that we allow our local communities to make those judgments based upon what they believe is right and wrong. And frankly, I kind of like this example. This is a situation where the community got involved and started it sounds like, lobbying the local prosecution office to say, listen, this is not fair given our constraints in our community. So to me, I think it's actually a good example.
Mm.
Yeah, I was going to say too, we're still talking about adults that just happen to be students. We're not talking about juveniles, at least in our context. I don't know about that last story. Were they
the
juveniles?
last story was juveniles, yeah.
Juveniles, okay. We still have a problem with the juvenile.
She was 24, they were 15.
That's a lot. 15 is young. 15 is young.
Yeah, there are a lot of stories like this, and they keep coming out, and that's kind of why I wanted to do an episode on my channel about this today. The issue is that there are a lot of female predators. There are a lot of women like her. I mean, it's really surprising that she got charged in the first place. It's about, I think the rate is 5% of SOs, people who offend, they are women. It's 5%, 95% male. The issue is that in reported cases where it's adults and minors, it's about 20% female. But according to surveys that have been done, it's actually a 59% female amount when you're talking about somebody who's 15 or younger with a 5-year age difference or more. And so, in fact, there are a lot of female predators. So the fact that she got charged in the first place is astounding because it's very rare. I think that's going to come out more and more because parents are looking at their kids' phones and they're seeing, texts from their teachers with like nudes and things like that. It's really disturbing. And what I don't understand is why it's so important that she's a cheerleader and that she's hot. Does that make it less offensive?
I'll tell you why. Okay. I mean, I made a joke that.
I mean, I understand, but I want to hear your take.
I made a joke about how it's a lesser sentence if the perp is good looking.
Yeah.
And the reason socially that happens is because when people are assessing the situation, inherently, I think they're thinking, well, I would engage that perp.
I would have had a good time if I was
15. That's what they're thinking. They're thinking
all the guys' heads on the thing are like,
on some level, they're like, wow, they almost envy the kid. No, and that's what I'm saying. If the perp is good looking enough, there's a certain envy of the kid. They're like, wow, I would take.
And I can see the same for.
I'm speaking in reality as to what's going through, what goes through a person's mind is why society is not as condemning as perhaps they should be, and failing to recognize that this is a child who can't make actual real decisions in themselves about the relationship that they're in, and that they are a victim whether or not they know it. But that's why I think we as a society tend to not really look at it the same way. If the perp is someone who's hideous looking, I think it's far easier on a natural level to condemn the perp and be like, wow, what a terrible person.
Right. There's actually a Twitter account called Mug Shotties, like
yeah, I've seen that.
Attractive women's mugshots. And it's really interesting because there are a lot of female perps who do this kind of thing, who are charged with this kind of crime. The only time I've ever seen, any woman who has been a predator, who has victimized, a kid that age, the only time I've ever seen people unequivocally say, lock her up, she's a monster, is when she was hideous. There was just one very ugly woman, and everybody realized and agreed that this was a crime. And then there's this idea that, well, what is the kid complaining about? She was hot. I would have enjoyed that. Nobody ever asks, why would a 20-something-year-old woman, 30-something-year-old woman be interested in a teenager, in a child? There's something wrong with that. I mean, I'm 30, and the idea of even like a 15-year-old coming up to me and saying, I have a crush on you, that would make me extremely uncomfortable. The idea that a woman would go, oh yeah, what do you want to do about it? I mean, can you believe that? Can you believe that any woman like that would, but she's attractive. So you can't really see her as, a predator, but isn't she?
But see, I think I got to agree with the guys here. I think internally, we're all 15 and that was a fantasy. An NFL cheerleader comes to your door, hey,
sure,
yeah, so and I think, like Joe is saying, the law should look past that, but I think just as human beings, we can't look past it as men. And it's interesting because generally, male juries are tougher on blank suspects than all female juries, because for some reason, female juries, they judge the victim more than they judge the perpetrator. So it's an interesting scenario sometimes.
The other thing, the reason why I brought up should we treat it differently is because I believe men and women view that act very differently as well. And so even talking about that act with others or between others, they view it very differently. And so the assumption is that, the male perpetrator is somehow manipulating the female victim, as opposed to when it's the male victim and the female perpetrator, there's no manipulation needed. You don't need to manipulate a 15-year-old boy. A stiff wind can do that. So I think that's why it's viewed differently. And that's why I was just wondering if it should be treated differently. And I understand why we don't want to, but just from a conversation standpoint.
Let me move on to the next story. So now let's get into some politics. Unfortunately, so Donald Trump was removed from the ballot in Colorado, but last time we spoke, he had just been removed from the ballot in Maine. Now, all the news, everybody was cheering, yeah, he's off the ballot, but he's been returned.
Who are you hanging out with that's cheering?
Oh, go to Reddit. So this is crazy. So if you go to Reddit and type in Nate the lawyer, Trump supporter, Nate's blah, blah, blah. And then if you come here, Nate the lawyer, TDS,
I'm just wondering who you're hanging out with. I haven't met a single person who's cheering, but you're like,
you're in the right wing circle.
Nate, did you register as a Republican without people knowing?
You got to get to the left wing circles, baby. So they are cheering that he's gone. 50, but I think they take polls 50% of the country cheering. But anyway, so they're cheering that he's gone, but Trump is now back on the ballot in both states. So I'm gonna throw it to Southern Law because he's going to tell us what Maine did, particularly to kind of make the big announcement that he's off the ballot, but really that's not the full story. Go ahead, Southern.
Yeah, let me see if I can. I don't know if you want to pull it up, Nate. You can if you want to. The actual notice of decision that she did in Maine, which I'm sure
this is the Secretary of State you're talking about.
Shut up, Bellows.
Yeah, and I think
here it is.
I'm sure Trump supporters think this was a well-reasoned decision that she did.
If she engaged in statutory, they throw the book at her.
Yeah, I don't. But if you go down to if you go to page 34, that's the last page of it. She pulled a little shenanigan that I don't know has been put out in the press yet, because when Colorado issued their decision, they had within it that it was stayed if there was an appeal to the Supreme Court up until that appeal was decided, right? And the media didn't want to report that at first. It wasn't something that came later. It was in the context of the decision. And I think they've done a little bit of the same thing here, because if you see there, it says, given the compressed time frame, the novel constitutional questions involved, the importance of this case, ballot preparation deadlines, I will suspend the effect of my decision until the Superior Court rules on any appeal or time to appeal under 21A Section 337 has expired. So I don't know what's going on with this, but I assume somebody is therefore appealing to the Superior Court. Whatever they do, somebody's going to appeal from that, and so forth and so on. It does say that the appeal would need to be within 5 days, so maybe that has happened. I'm not sure. But she stayed her decision, at least temporarily, to allow it to get into the judicial sector, which if it ever is going to be decided, that's where it needs to be. And in fact, it needs to be decided by the Supreme Court. So I don't know that anybody reported on this, and I'm not sure what's happening with it, but don't be surprised if you hear shortly Trump back on the ballot in Maine because of this, even though it was contained within the decision itself.
Did they use the same justification for the decision that Colorado did? Like sort of the same argument, the 14th Amendment and all that?
Oh, let's see. I think they don't reach this conclusion lightly. Democracy is sacred. This is part of it.
Blah, blah, blah.
I'm mindful that no Secretary of State has ever deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment. But I'm also mindful that no presidential candidate has ever before engaged in insurrection. The oath I swore to uphold the Constitution comes first above all. And her duty with Maine's election laws presented. So yes, it does engage the Section 3 of the 14th Amendment, then applies it back to the Maine law, kind of like what happened to Colorado, and all this stuff needs to rocket on up to the Supreme Court.
The problem on this whole thing is a factual issue. That's the thing that's going to be difficult for the U.S. Supreme Court. And that, especially with respect to the Colorado ruling, where they talked about they basically, as a matter of fact, they determined that Trump engaged, and in this case, it was an implied engagement, if I can use those crazy words, for insurrection. And so that's what's going to be interesting. I'm hoping that when the U.S. Supreme Court does rule, that they don't make crappy law, because I could see this being a situation where they're either politically motivated or they're just looking forward to the future of the country and they start messing with factual findings. I'm hoping that they move to the 14th Amendment issue and they basically say there's lack of standing. My one problem, and maybe Joe or maybe Steve can help me with this, is I don't know what was the standing of the original Colorado plaintiffs way back when, September, by the way. This is the fastest lawsuit I've ever seen. I've been in federal practice for a long time, and I can't believe, and state practice too, that it moved that quickly, even though the statute required a speedy, expedited system. But regardless, I don't know if that can be applied in the Colorado thing. If that can, then a lot of these lawsuits, including the one that just was decided today in California, of all places, where they say, listen, the plaintiffs just don't have standing to do this. They allege some kind of general harm about having a various candidate on the ballot, but it's not significant enough for them to make a constitutional ruling on that. But do you guys know about the standing issue in Colorado? I don't know.
I don't remember spending a lot of time looking at the issue of standing, only because there was so many just intellectually delicious issues of law related to this 14th Amendment. I mean, I last night I was actually on with Nick Ricada, and we spent an hour and a half, and he calls this his favorite legal issue since he started law school, because he's like, there's so many interesting novel issues that have never been addressed by any court ever before on a statute, on an amendment that's 150 years old. Yes. And nobody knows anything about it. And it's
the definition of office.
Or an officer of the United States rather than officer, and the distinction thereof, which is something few people actually really consider before, and just even a basic issue which I've had conflicts with. I'm not even sure if members of this panel or certainly other people who are in this sphere, as to how literally do we interpret every word of the Constitution. How much are we supposed to dissect every single word when we're properly trying to interpret an amendment? And this is an important thing, because a lot of Trump's points are really focused on things like the fact that it says officer of the United States instead of just officer. And if you don't really dissect it that carefully, it doesn't really matter. It wouldn't matter that much. And there's so many different points of dissection that I'll tell you, even last night, I came up with a new one that I never thought of before, which is a distinction between the 13th and the 14th Amendment, where they basically say that with respect to the 13th Amendment, in Section 2, it says Congress shall have power to enforce this. And the reason they would put that in is because under federalism, Congress is very limited in general as to what areas they can legislate. So in order to have that power, the natural assumption is they would not have that power unless there's an amendment specifically giving that power, because really they're only able to handle interstate commerce. So, and something that's not interstate commerce, especially if you think back into the late 1800s, before federalism really became eradicated under Wickard v. Filburn, and the new with that decision on the New Deal in the mid 1940s. But back in the 1870s, late 1860s, 1870s, Congress was much more limited in what they could pass laws about. So you can understand why they need to put an amendment saying, okay, this is an area we're going to give this power to Congress. But does that mean it's exclusively Congress? Well, here's an interesting thing. In the 13th Amendment, it says Congress shall have power. So that would give them power, but that perhaps not exclusive power. In the 14th Amendment, it says Congress shall have the power to affect laws, which seems to be that there's an exclusivity of the power that only Congress has the ability to write laws there. And that's something that's really just dissecting the word "the" and why they put the word "the" in there when they didn't put it in the 13th Amendment. Now, that level of dissection really requires looking at Constitution as if it's gospel, as if every word that's in there has a purpose and has a meaning. And there's some people who will interpret the Constitution that way, some very intelligent attorneys who will interpret that way, and some very intelligent attorneys who say that's a little bit too close of a dissection. And where the Supreme Court falls on this, nobody knows where they're going to fall. But I will tell you that to me the most likely area that Trump will succeed, and I'd be shocked if the Supreme Court does not enable him to succeed, but the most likely area for him to succeed is the most neutral political issue, wherein the Supreme Court will just say, this is not something the states can decide. They don't have the power here. So forget about standing, but they just don't. That this is something that only Congress, that they'll interpret as only Congress has this power.
Hey, Joe, I just pulled up the congressional debates on the 14th Amendment. What's interesting is that a prior draft had the word president and vice president of the United States in it, and then they removed it. So that's very telling.
This came up. But then on the other side, what came up was that there was a conversation that supposedly happened in Congress in 1867 when they were putting this thing together, where someone asked, why are we leaving president out? And there was a response from someone which said, well, it says officer, so officer includes president. So those are the two things that people are looking at, which seem completely contradictory as to
it says it says president, vice president, or officer. When they're debating it. So I mean, it was originally in there, and then they took it out.
I'm telling you right now, I could probably spend another 40 hours having discussion about this because there's
reading through it now.
There's so many interesting issues just on the phrasing.
Let's check back into Maine for just a moment here and the confidence of their decision, which she says on page 18 at the top.
Hold on, let me pull it up real quick.
Yeah,
she says
18, right?
Yeah.
Oops. Let me put this on the screen.
Well, I am. Let me get there.
18 at the top.
Top of 18. While I am cognizant of the fact that my decision could soon be rendered a nullity by the decision of the United States Supreme Court in Anderson, I think that's the Colorado case, that possibility does not relieve me of my responsibility to act. But I think it is showing that her analysis is tied into this 14th Amendment thing, and that this is at least fairly put an acknowledgement that the United States Supreme Court really should be handling this, right? Even she's saying that, and she suspended her own decision.
Even the Supreme Court of Colorado said, hey, and we will defer to the Supreme Court of the United States if they overrule us, as if they need to write those words in order for that to actually happen, as if they don't write it like that it still wouldn't override them.
Well,
it's their way of saying we know that this is going to be decided on levels way beyond.
And she's admitting here that if that happens in Colorado, that obviously is going to control what she's doing, and I don't know if that makes the media either.
Yeah. So in other words, go ahead.
I view these decisions as amicus briefs. I swear to God. I think they're political statements. Why even go that far? Why write a three sentence decision and just say, you know what, I'm going to defer based upon the ruling of the U.S. Supreme Court? It's very simple. So I really think this is mostly a political thing, but I am interested in is how the Supreme Court is going to resolve this, because the problem is this is going to create precedent, as it already has, for we're not just the U.S. president, but most officers elected to federal office, and it's going to really F up, pardon my language, our system. So I'm hoping that the Supreme Court doesn't make bad law on this, and I'm hoping they actually take not a neutral position. They take a reasoned, thoughtful decision that even if it happens to go on the right side of politics, but just so that we can get through this, because I do think this is going to be a problem every single time, every candidate, I don't care if it's Nikki Haley or Vivek, whatever it is, they're going to get these lawsuits that are going to prevent them from running. And as a result, we're going to have less and less qualified people ever want to take office.
And here's an interesting thing. Imagine next week Biden gives a speech in Arkansas. Okay, this is something that Nick was pointing out. He asked a question to one of his classes, because he teaches classes. Because I just want you to consider this. Imagine he gives a speech in some county, in some town, to 30,000 people, or that the whole town has 30,000 people. And he gives a speech there. And there's a claim that's made by the local district attorney and some really red, really anti, some ultra MAGA. And he says, there was an effort there by him to incite insurrection. And I'm going to charge the president with inciting insurrection. So all of a sudden now, would some state in a foreign place be able to say, well, there's a claim that he incited insurrection. So now even a different state could say, there's a claim he incited insurrection. There you go. There's the Section 3 of the 14th Amendment. We're not allowing Biden on the ticket. I mean, think of how insane that could, taken if you take this at face value as being a legitimate decision, this really could run amok exactly what you were just saying. It could be applied to Nikki Haley, it could be applied to Vivek, it could be applied to any person on the planet that there's political division over, that they would just be like, hey, well, we don't like him, and I'm going to, and all you have to do is if you just bring a charge, then there's justification now for a Secretary of State to say, well, I don't know, maybe they engaged in insurrection. I can't let them on the ballot.
But am I the only one that wants the case in Colorado and Maine to be upheld under the section 1 of Article 2 of the Constitution?
I think so.
Well, the reason why is because it's up to the states. The only role for the federal government is to receive the electors from the states. How those electors are chosen and how they vote is 100% up to the states.
So if the state says, I don't want this person to be on our ballot, that's the state's decision.
Yeah, because that's the only federal power.
Then you wouldn't.
It's the only role the federal government has.
You wouldn't need then you don't need the 14th Amendment.
You don't need the 14th Amendment.
See, the issue here is that they're citing the 14th Amendment as their authority.
I know, and that's why I think they screwed up.
Yeah,
that's why I think they screwed up. If they had argued Article 2, Section 1, the federal government must accept our electors as we send them, end of story, and we get to choose. Because it literally says in there, in a manner selected as provided by the states, the state legislators.
So by that logic, any state could say that about any person ever that they want. That they're just keeping this individual off the ballot. And think about the political division that would create.
And also, they're relying on the 14th Amendment to even come to this decision. So we're kind of moving away from the relevance of this case to whether or not a state should be able to deny someone off the ballot. So if we really focus on what this is a 14th Amendment issue that they're relying on. They're saying, listen, you engage in insurrection, so you're not eligible for office. So therefore, the Secretary of State must take you off based upon federal law.
Yeah. But there is one other case that's on point. The guy's name is John Christie. He's from Georgia. He was part of the Confederacy, served in the Confederacy, and we won a seat as a U.S. representative of Georgia, but the governor refused him his commission and refused him his seat in Congress. It didn't go to court, but the judges, the reasoning of the governor was that he was disqualified under Section 3 of the 14th Amendment. And that's why he wasn't able to, that's why he didn't certify him. But the differences with that situation is that he's with the Confederacy. So it's obvious he was insurrection. I think the issue is who's determining what insurrection is. But the precedent here is the fact that an executive official from a state can deny someone being on the ballot or even deny them access to their seat in Congress because this guy was elected based on Section 3 of the 14th Amendment. But again,
at what stage was that?
This was after the Civil War in 1868. The
guy had been elected, or he had not been elected.
Yeah, he had won the election, and the governor
talking about the judge.
No, this is for House of Representatives, and the governor of Georgia refused give him his commission, and Congress refused to seat him when he made it to Congress. So they said, we're not going to say that you won the election. And then when he went to Congress said, no, the state, you got to deal with the state.
So the interesting thing here about that, though, is that Congress has the power to regulate itself.
Yes.
So if they say, so whatever Congress decides on their own, it's very difficult for someone to come in and say, no, you have to take him in there, because they have the authority to regulate their own body. So if Congress keeps him out, that's less interesting to me than if a governor has that authority.
Well, the governor's the one that said, we're not going to give you the commission, but the person went to Congress. Now, this is a crazy story because Georgia, the people who were in the election, which is crazy. So the guy who won the election, they said, you're not certified. So Congress said, we're not even going to seat you. But then the guy who lost, his name was John Wimpy. They actually certified him for the seat, but then was found that he served in the Confederate Army, and then they disqualified him later. And so neither of them actually served in Congress, even though, so the winner and the loser never served because they both. But again, I think it's different because if you're serving in the Confederacy, you obviously served in an insurrection. So
yeah, I mean,
I know you're never going to find a case on point, but this is just the closest that where a government.
But again, they're deferring to the states because every article, when it talks about this, elected representatives, whether it's the president, the House, it used to be the Senate was appointed by the legislature. Now it's elected, but it's up to the states on how those elections work. That's why when there were issues with the elections, you can go back to Gore v. Bush, and you can go to 2020 and all that stuff. You were suing the individual states, the counties, secretary of states, because that's where the decision is made based on the state law, not federal law. And
but the reason I think this is asinine, the reason I think that the entire claim is literally an asinine claim is because if you understand anything about the Civil War, that the primary issue there was certainly abolition. And the second issue there was state power. And the South lost on issues of state power. So for anyone to interpret one of these Reconstruction era amendments as designed to give states power over the federal government, that's what the purpose was, that now a state can decide who's going to be the president or who's not going to be the president, and they should have, that's what the purpose of this amendment is such an ass backward perspective as to what the Reconstruction era was all about, that you're literally turning reality on its head to pretend that that's actually something that was an intent of the government in 1868.
Just so everybody's clear too, the 14th Amendment was the largest expansion of federal government authority over state governments, because remember, it's the no state shall, and they put that in particularly to let the federal courts and the federal government have authority over states and protecting the liberties of.
And now it's being used to say, well, here's an arrow for the state to shoot at who can
but
be
it
the
doesn't take away all the
backward.
states' rights. It doesn't alleviate Article 2, Section 1. It doesn't say
I agree
that
with you. It doesn't. I agree.
It
okay,
doesn't,
so
but,
it doesn't go far. It doesn't go far enough for the argument that's trying to be made here.
Yeah,
but how about this to Joe's point? Joe, I don't know if you've mentioned this before. Obviously, they have the thing about the senator or representative talking about Section 3 of 14th Amendment. But it says, or hold any office, civil or military, under the United States or under any state, right? Mm-hmm. So in theory, under the 14th Amendment, you can't even be the Secretary of State of a state if you've engaged in insurrection or given aid or comfort. So now, down the rabbit hole, why don't we throw off any Secretary of State, anybody who's in a state assembly, anything at all, anywhere, if we think they've given aid and comfort to somebody who's an insurrectionist, which could be this, that, or the other. I mean, the whole thing. Why have elections? Why don't we just argue about who's more insurrection-y?
That happened in 2022 at a guy named Griffin. He took the oath of county commissioner. He went to January 6th. They said it was an insurrection. He went to court in New Mexico in the case White v. Griffin, said that since he was in insurrection, they disqualified him from his position. Wow. So yes.
All right.
And
that's interesting.
And there's also
case, or was that a case?
That's a state case. The name of the case is Griffin. White v. Griffin. And there's another one for county sheriff, postmaster general, and a district attorney. All of those were the same thing, engaged in insurrection on the local level. Louisiana
they wanted to prevent another civil war, is what they wanted to do.
But this goes to Joe's point that this was to crank down on the states.
Correct.
Because they're saying, state, you can't even have this guy in your office if we find he was in an insurrection. So that's limiting the state power.
Well, the reason why I asked if that was a state case or a federal case is because who does the deciding?
Well, in that case, it was the state who was deciding because it was based on he was taking a state position under state law.
But shouldn't it be a federal court that decides, since this is
you would think
federal,
so?
Yeah,
think so.
But don't forget, state courts are courts of general jurisdiction, so they can still, if the person maybe wants to appeal to the federal courts, but it's still a state law issue.
Oh no, Ian, we're losing you.
His battery died.
And again, just for the last case in 2022, he was convicted of trespass, but acquitted of disorderly conduct. And they said the conviction of trespass at the Capitol was enough
Wow.
to get from the insurrection.
And David Nelson, you've pulled up a chat that he just threw out there.
David Nelson, go ahead.
That he points out that.
Oh yeah,
I had the same thought. When you look at what happened in Oregon, where they're attacking a federal courthouse, which this is clearly an insurrection. That any of these politicians who are fundraising for all those things that were happening in the summer of love of 2020, that every single one of them arguably has been giving their after taking an oath of office, gave their support to an insurrection, and it's unequivocally a far more direct aid, far more direct engagement, and far more directly an insurrection. And yet there's never been any talk about removing Kamala based on the fact that, hey, she's raising money, or AOC, or all these people are saying, yeah, we're going to keep on fighting, when they're clearly supporting the efforts of Chaz, the efforts of all these different things where they literally are overthrowing the government. And
I just recorded it the other day because I was going to put it up there and say I was going to do it in reference to like Turtle Boy and the whole thing going on with Karen Reed case. But is she picketing a court and attempting to influence the jury and intimidate witnesses when she was standing outside that courthouse? But I was just going to put it up the other day. I didn't get to it yet. But yeah, no, that's a great point.
Let me pay some bills for Eric. Clinton guilty by association, Lewinsky info. I understand what you're talking about. I think he's saying that, Lewinsky was 20-year-old intern and he's the president, and the cigar issue. So yeah, it's does he like him?
Likes him young. Yeah.
He likes him young. There's still a lot of important things that are missing and won't see the light of day. If you recall, the FBI ran away with Epstein's safe full of blackmail materials when they arrested him in 2019. Yes, and there's also been some suggestion that because all these powerful men, he had the information on them doing this thing with these massages, that they were all sources for the CIA or for, I forgot the Mossad or something like that. Some other
Mossad.
Mm-hmm. Yeah. So, which makes sense if you have these wealthy men doing these illegal activities. Yeah, I can see it happening. Now,
given the fact that no one knows how he made his money, I think speculation has some real tethering to its claims that he was an asset. Given the no one knows how he got his money, given the Acosta deal that he got when he was the first time he was brought up on charges, which was the most ridiculous sweetheart deal imaginable for the crimes that he was being charged with. And I mean, literally he was able to walk out of prison all day long and then just go back there to sleep at night. I mean, in this luxury, one person prison. I mean, it was ridiculous, and that was for like a handful of months that he did that, a year that he had to do that. I mean, that's just ridiculous, and it makes one think that perhaps that these claims that he's related to the CIA, certainly it seems.
It's not something you can just ignore.
My gut says yes, this dude was an asset.
I can't. That's something I can ignore. Yeah, I think exactly what you said. You can't dismiss it. You can't just say it's just But so this one is, how messed up is the mother? So this is for the case that we just saw in North Carolina, the statutory blank for adults. How messed up? There was a mother who stalked her own son, GPS'd it, and then reported the teacher after catching them in the act. She called the police while they were in the car having relations.
I have to imagine the son was not probably the best behaved if she needs to GPS him and then track him down. Though back in my day, my mom didn't need GPS. She knew exactly where I was, even in the middle of the night. I don't know how she found me.
Aren't we all GPS now with cell phones?
That's true. Yeah.
Find my phone.
I want to pick your brains on a topic that I've not yet raised on my own show.
Hold on. Let me just run through these last three, and then we'll be. At 18, you have a different mindset and relationship with teachers than college professors. 5-year thing is ridiculous, but she's not right for doing a student that is freshly 18.
Freshly 18. I like that. Freshly 18. We have a new line. It's old 18 versus freshly 18.
Joe debate with Nick was great. Love you, Joe.
Thank you.
And this last one, How about the fact that there was no insurrection? Trump had nothing to do
Agreed.
with the January 6th false flag, and nobody has
that's
evidence
besides
otherwise.
the point.
An insurrection is what the court said it is, and it seems like the courts are saying that this would ever happen.
Based upon dictionary definitions, by the way.
Again, and I'm going to say, this is the first insurrection where the guy goes and tells the people, go and protest peacefully at the Capitol.
Now go home.
Well, he used the word fight, Nate. He said fight. You got to fight. How dangerous is that word?
Well, it's like that's not even mentioned. Go ahead, Joe. I know I cut you off.
No, that's okay. There's a report that came out, which I'm very torn about how I feel about this, and it relates to the topic really we're talking more about earlier in this show, where this 16-year-old girl who was on Meta and in the metaverse, and she was her avatar was physically ganged up on in a way that was very apparently aggressive and hostile and somewhat sexual, and that there's an investigation into charging the violators with a crime of that even though she never was physically touched by any person, but that she's emotionally distraught, like her, she was basically mind statutoried, that based on that these individuals should be punished. And I'm wondering what the thoughts of the panel here are with respect to charges being brought against these individuals for their I guess mental assault of her. And
well, I think it's clear. I think it's based upon harassment. If we have laws against harassment, and in this case, from what I understand, there's sounds, there's anime or whatever animated images, there's speech. If that constitutes harassment in real life, then there's an issue right there. But if there is any other allegations, like some sort of physical abuse or something to that nature, that's not a battery, and that's not something that
what are they charging with? Is it harassment?
Well, there's an investigation that's happening. There's no charges that have been brought. But I was wondering what you all think about the concept, because I'll tell you this much. I learned of this story because I happened to have Michael Knowles on yesterday, and he was talking about this, and he was defending the idea of going after them, and the logic that he was putting forward was that, he's like, yeah, I believe in freedom of speech and all that, but at the end of the day, there's a reason we look at this as the worst assault someone can have on someone, and it's not because of the physical damage, but it's because of the mental and emotional scarring that we can basically we recognize are part of this abuse. I'm just telling you what his philosophy was, and I wanted to. And the point is that all that same emotional and mental scarring, one would think would, that much of that, or at least much of it, would apply in this circumstance as well, and that would be a reason to go after them. And I sort of was like, bouncing this around in my brain for the last 24 hours, and that's why I wanted to get thoughts from all of you on this.
So the general harassment laws, and I'm just speaking, I know Michigan's, specifically. And just speaking generally about it, though, you have to have an unwanted communication generally after the person has said no. Like, it can't happen the first communication. They have to tell you no, then it's unwanted. Then you have to continue to communicate with them in such a way that causes them to have fear that something physical is going to happen to them or one of their loved ones. And it can be an emotional distress component of it, although you have to have the intent to have that. And they actually have to suffer the emotional distress, which in Michigan usually requires opening up your whole mental health record.
Right.
To go through things. And so
and a physical manifestation of the emotion.
And it has to be a physical manifestation of that emotional distress.
It sounds like an IED claim.
Yeah, it is. And so that's how you get to the harassment charge, at least in the state of Michigan. And I imagine it's fairly similar in most places. So you can do that in person. You can do that over the phone. You can do it with text. You can do it through social media. But you have to reach those levels. And if you don't get to those points, then it's not the harassment. And the reason is because you don't want to restrain people's freedom of speech, So
like right here, JL says I got killed in Fortnite. Arrest everyone.
Yeah, exactly. Yeah.
You bastards! You killed me.
I never expected to get my head down.
You were on my team. You left me alone.
For that, you have to call the Call of Duty Teabag Prosecution Task Force, and they'll look into it.
You know, I have a great case because I just handled one of these cases. It was electronic communication device, and I was looking up some cases, and there was one where a bunch of people were online trolling and talking bad about this girl and all the things they wanted to do to this girl, physical things, but she was never the intended target. She was never intended to see it, and things like that. And they're like, okay, so that obviously doesn't meet one of these elements that it's communicated to her, right? And so you have to hit all of those elements. So if you're not threatening physical violence, if you're not putting somebody, you have to have the intent to threaten them, and then they also have to perceive it. And it's at least in Michigan, it's a reasonable, it's a subjective and an objective standard. You have to meet both of those. So what's that playing?
I don't know.
Sorry, I heard something. But yeah, so there's it's a very fine, narrow.
We made the
line
lawyer
you
with
have to
Jeffrey
walk.
Tubinos, so I'm just.
The Tubin. I can't do it. No, well, no, I was actually setting up the clip for our last. Are you finished, MLS? I was just setting up our clip for our.
Yeah, no, I was just trying to find this case, but I don't remember what it is. I just looked at it last month, but that's fine.
Oh, all right. So here is the last one. This is judge attacked by defendant.
Oh, there we go. There we go. Everyone's seen this.
I put Mario music over mine. And
I just can't with that history. In accordance with the laws of the state of Nevada, this court.
He attacked the judge after she denied his attorney's request that he be sentenced to probation. The judge was hurt, and so was the courtroom marshal who tried to protect her in the attack. Inside Edition reached out to the judge and the suspect's attorney for comment, but did not hear back.
Attorney beat
Redding was booked back into jail on new charges, including
the court attorney. What are you doing?
That's your classic fifth man in the fight kind of hitting.
Yeah, exactly.
I know I'm not going to get back. I know he's not hitting me back. I'm going to be able to hit him. Yeah.
Is it too soon for a Mario Brothers riff on this?
They're saying just because of the
here we go.
The air that he got.
I think it's time to get a taste of something.
Black out everything.
Look at he goes to town on this guy.
It didn't even look like he put his hand on the thing. It looked
I know
like
he leaped over it.
It was a pure leap. That's what's so impressive. If he put his hands up on it, I'd be like, okay, that's a really good leap. Yeah. It's a remarkable leap considering the fact that he just was like he's high hurdling that thing.
Well, he is. And the other part too, if you watch the other angle, which is actually of the defendant himself, it's coming out of nowhere. I mean, from what I understand, it's a kind of a minimal crime that he was being prosecuted for, and he was wanting not to have jail time. And so because jail time was offered, was ordered, that's why he did that. But if you look at him, he's pretty calm. Like it was nothing like he's going or nothing.
Yeah,
it was out of the ordinary.
Yeah, he was just standing there, but I don't think he wasn't in custody, right? He's sitting in the back in the gallery with, I think, his mother or someone that's with him. And then they call his case and he walks up. I don't think he's expecting jail time. And what sets him off is the judge is sitting there looking through his record saying, well, he's got a lot of priors. I think we need something more than probation. And before she even says what it is, he loses it because I think at that point, he thinks he's going to jail.
Yep.
And
he's definitely going to be doing a lot of time in jail now.
Yeah.
Yeah, I looked it up. It looks like it's going to be 4-year sentence as a part of the max.
Yeah.
Okay. Yeah,
but plus the assault now, because they're getting them the assault on the judge, the assault on the court person, the assault on the police because the cop was hurt. So that's and then you're talking about maybe a felonious assault because of the
absolutely.
So,
if I see some people in the chat, if you want that, it's on my channel. I posted that video. So if you want the Mario Brother version, go for it.
There you go.
Oh yeah. Oh, so
thanks, MLS.
With that said, we have about almost 1,200 people watching. So this is the time we say our goodbyes. It's another great Friday. We've touched on a lot of different areas. Let's start with MLS. Let us know what you got coming up on the channel.
Yeah, so the next big thing I got coming up, of course, I always do Jody Arias on Tuesdays and Saturdays, but on January 11th, we're going to do a fundraising stream for Zachariah Anderson. If you don't know that case, we're going to talk about it from start to finish. It is a wrongful conviction, if there ever was a wrongful conviction. This gentleman was convicted on no body, no cell phone data, no eyewitness, no video witness, no video cameras or anything like that. One speck of DNA, which could have gotten there because he shared a relationship with the victim's current girlfriend, was his ex-girlfriend, and then they had kids together. One speck of DNA convicted this guy, and we're not even sure if it's even his DNA.
And no capacity to remove the body because he had a bad back, and it was like 300-pound guy that he had to move by himself.
And he had 15 minutes to do it in the time.
In a rolled up carpet.
Yes. And none of his DNA is anywhere at the crime scene. None of the victim's DNA is anywhere else. It's just, it's a disaster of a conviction. And so we're going to be talking about that. And with his brother will be on the channel with me.
Solomon.
Solomon's a good kid.
He's great.
And that'll be January 11th. That's my next thing. And then I got a couple of Lego streams. And so those are always fun. And Joe did a Lego stream. You got to check out. We have a clip of it as well, so you don't have to watch all 6 hours that it took him. 10 pieces per hour. That's what you built. That was your rate. Ooh. 10 Lego bricks per hour was your build rate, Joe. That was rough.
Well, go ahead, Joe, because we always leave you for last. But now let's get you in right now, so you can get the whole thing out, and then we'll move to Eon. So go ahead.
It's 10 pieces per hour, but I was stopping. I told a 40-minute story in the middle where I wasn't building anything. That's first and foremost. Second of all, my bags weren't numbered. My bags were not. I'm sitting here plucking this bag. Everyone else, they're like, "Wait, you don't see the number 6 on your bag?" I'm like, "No, I've got like 14 bags here." Whatever. Whatever.
If you want to see a good interview of Joe while he's building Legos, or like Steve Gosney and Steph, the author nerd, we had a bunch of people on.
And I was sick as a dog. Yeah. So anyway, coming up for me this week, January 9th, which I think is Tuesday, right? That's Tuesday? That sounds like Tuesday to me. So January 9th at 9:30 a.m., the D.C. Circuit Court is holding oral arguments where they're going to decide whether or not President Trump should be deemed immune to his to any prosecutions. And I will tell you this much. They say they're very interested in hearing from the amici. Some people call it amici, some call it Don Amici. You can call it whatever you want, but they want to hear from those who filed an amicus brief. And one of those amicus briefs, which was filed by Edwin Meese, former Attorney General, was a really well written, very sound argument that Jack Smith has zero capacity to bring any of these charges because he's not constitutionally allowed to act on behalf of the United States, which would imply that anything that case and the Florida case they have to be dismissed immediately. And that's one of them. And I would anticipate that we're likely to hear our oral arguments. I plan on airing that 9:30 in the morning Eastern time on January 9th, where we will hear the oral arguments and presenting that and reviewing that with my audience as it's happening. So I urge you guys to make sure that you sub up a good Lawgic, or it's also going to be on my other Trump trial channel. It's a very difficult thing to say, Trump trial channel. So, and I urge you guys to check that. It's gonna be, I have my regular streams all the time, but that's something I plan on covering Tuesday, January 9th at 9:30 a.m. You don't want to miss it.
Now, with that issue, I remember the issue seems to be the president has sovereign immunity while he's president, and these acts that he's being charged for were acts that he committed as president. But if he committed ministerial acts, meaning acts in furtherance of the country and in furtherance of his job, he's totally immune. He can't be prosecuted for anything. That's like the Obama, for instance, think about Obama drone killings of American citizens overseas. He can never be charged because that was in furtherance of the president. But if he does something in his personal capacity, Example of that, Bill Clinton and the Paula Jones suit. They deemed that to be in his personal capacity, so he wasn't immune to lawsuits. So the court now has to determine whether the statements about the election not being insecure, were they in his capacity, in his ministerial capacity, or his personal capacity. Am I getting that right, Joe?
That's partly. I mean, there's definitely a dispute as to whether or not that's part of his functions as president to oversee elections, which I think that on first blush, someone would assume that it is part of his capacity.
Yes.
But the more you break down the technical duties of the president, the more you're able to try and assail that argument. I still think that should be interpreted rather broadly, because the president is supposed to be acting broadly in general. So to me, it's logical to say that when we're looking at things that are within his capacity as president, it only makes sense to interpret that on a fairly broad scale, because you don't want the president handcuffed and doing something, saying, well, I'm not acting as president when I'm handling this thing, and therefore I have to, I can't step in that zone. That's not how you have an effective leader. So I don't think that would that's a logical interpretation. I think it should be very broad, and I think that this, broadly speaking, certainly would fit into something that he could not be indicted for unless he was first impeached and then convicted in the Senate under the impeachment clause. So, but we'll see what the circuit court says, and then after they weigh in, we'll probably later hear from the Supreme Court on these issues as well. But that's
fascinating. Ian, let's close out the show. Let the people know who you are and what they can find you and what you got coming up.
Well, I just want to say off the bat, that's going to be super interesting, and I'm going to be tuning in too, because I just think there's a situation now where we're going to have less and less people interested in being president because they know they're going to be president, they're going to be sued, they're going to be criminally charged after they're out of office. So I think it's absolutely ridiculous, but I'll move that aside. Kind of along those lines, though, Nate, I think you know as well as I do, on this platform that we're on right now, I have been so censored. My videos disappear, are demonetized all the time. And so I made a decision on January 1st that I'm kind of doing a multi-platform presentation of my issues. I'm a legal analyst of alt media issues. So I look at these issues. There's a lot of laws that people don't know about that have these little clauses, like maybe Donald Trump's, executive order back in 2017, which talks about, the travel ban and the ramifications for that. So what I've decided to do is I am on YouTube, I am on Instagram, I am on Facebook, I am on X, of course, all the platforms, but I usually do shorter videos. And then I lead you to my main platform, which is Substack, at Ian Corzine on Substack. It's a great platform. Generally, they don't censor. I have never had a problem with them yet. They allow all sorts of different kinds of video and written posts. And so what I do is basically I have a short version of my video, and that leads to a longer 8 to 10 minute version on Substack. You can join it for free. You don't have to pay any money. Obviously, you can if you'd like, but you don't have to. And what I'm working on right now, and what I just recently published yesterday, was my full rundown of the Jeffrey Epstein, I was going to say list of documents, and basically the Bill Clinton's involvement in that. And so if you want my full rundown on that, just go to Substack at Ian Corzine. You can find the links by going to my Instagram or TikTok or whatever. But I spent some time on this, and I think there's going to be some stuff that we didn't even get into today that is worthwhile for the viewers out there.
Awesome.
Well, listen, thank you, and please check out Ian on Substack, because it's funny. I got 2 videos right now, which is killing me because YouTube has demonetized them both. So then I censored them as much as possible, and they still know it's still not good enough. So, and did you guys know it's not only like because at YouTube now they make you go through the whole when you get over 100,000 subs, they make you sit down with the program manager, and he's like, you have to go through the whole list again. So he went through the whole list. And the video that we used, I'm like, this video is good. He's like, yes, it's good. It should work. No good. I'm like, why? Because it was implied. Something was implied. So I'm like, oh my God. So YouTube
these days it's not even good enough just to omit words or to omit scenes or to have violent scenes. Actually, AI or large language models are getting so good that they're able to get context. And so even if we do the dumb thing where we say essay or all those things, those are all picked up, especially in titles. So to be honest, I've kind of had it. It's very frustrating because I don't want to talk. I don't use bad words. I don't want to go. It's for general consuming. But the problem is that I can't get my long form videos out, which with issues that I really think people need to know about. So Substack at Ian Corzine.
Yes,
it's so random. I got struck for the first time the other day because I violated their content rules or whatever, and it was literally a clip from South Park, and so I thought maybe I'd get like a copyright claim or something, but no, content violations. I got struck.
Wow,
like the whole thing was pulled down. I got the warning. I had to do the class.
Mm-hmm.
Yeah.
Well, as you guys see, we're struggling on YouTube. That's why you need to subscribe to everybody's channel and help us make this great content. Because if you like this content and you like us to be able to be free with giving you this content, the only way we can do it is with fan support. We can't, because obviously you see what we have to go through. Matter of fact, look at X, right? Look at what the billionaire is going through. So just imagine on our level the struggle. But with that said, thank you guys so much for joining in. Thank you guys for watching all the way to the end. And if you watched to hour 43 minutes in and haven't subscribed to the channel, what are you doing? You're killing us here. Come on, you're an hour 43 minutes in. All these people in the chat just need to hit that subscribe button right now and take us to the promised land. With that said, my name is Nathan Lloyd, and I'll see you in the next one. Peace.